Good evening to the aspirants of JCJ 2022, the main examination, which is going to be held on 26 November 2022 if it is not postponed. Please read what I posted on the screen. Participant, anyone can unmute and read what is posted on the screen. Participants, unmute and read what I posted on the screen. I think we are having a little problem regarding your net is concerned because I got the notification that Harika is buffering.
Sir, your voice is not clear now.
Yes, now read what I posted on the screen.
Commencement of civil trials and amendment of pleadings.
Yes, welcome to the aspirants of JCJ 2022 main examination online 15-11-2022, the commencement of the civil trials and amendment of the pleadings by the Professor Dr. Mohammed Saheb Hussain, Professor of Law, South Monza, Tanzania, East Africa. So now, without wasting the time, let me go to the yesterday class continuation is concerned, and yesterday class we are dealing about the Order 7, Rule 17, Code of Civil Procedure. Amendment of pleadings. The court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties. So up to this extent we dealt in yesterday class. Now let us provide the explanation for the above is, at any stage of the proceedings, court may either partly or alter or amend or allow the pleadings in such a manner on such terms which may be just for a justification of the party. Excuse me. And all such amendments shall be made as may be necessary for the purpose of determining the real question, what is the controversy between the parties are. So amendment would be allowed at any stage, and the partially or in the amend his pleadings in a better manner to end up the justice, to give the justice, to be just. Provided that no application for amendment shall be allowed, then the provision says, provided that no application for the amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, a party could not have raised the matter before the commencement of a trial. Of course, they put another consideration also. Even though party is so diligent that they could make it out, there should be change in the pleading before the commencement of the trial. Even though such a thing would be there, the party could make it out, but still they could not make the amendment to the pleadings. Then the court say no application of amendment shall be allowed after the trial has commenced. So that was the another point. It is made it clear. But there is a controversy from one court to another court in this matter. So in which stage a civil suit pleading can be amended? In which stage a civil suit pleading can be amended? Participants, could you read this paragraph which I highlighted?
Yes, sir.
Go ahead.
The provision related to amendment of pleading gives power to the civil court to allow participant to alter, amend, modify the pleadings at any stage of proceedings. Provision for amendment of pleading has been stated in Order 6, Rule 17 of Code of Civil Procedure Code. Sorry, sir.
Okay,
But the court will allow amendment.
That much is enough. Okay, the provision related to the amendment of pleading gives power to the civil court. What power? To allow the parties, what? To alter and amend or modify the pleading at any stage of the proceedings. They say any stage of the proceeding, but the upper provision say, they say once the trial is commenced. See, is it not the controversy? Here any stage, and there before the commencement of the trial. So provision for the amendment of pleading has been stated in Order 6, Rule 17 of the Code of Civil Procedure. Is it the correct way of writing the Order 6, Rule 17? If you know it, you tell me. If you don't know it, you say pass on.
Pass on, sir.
Order we cannot write in Arabic numerals. I repeat, order should not be written in Arabic numerals. Then what should be written? How should be written?
Only Roman number.
Roman capital. Order
Yes,
6, Rule 17 of the Code of Civil Procedure. When you write the Code of Civil Procedure, the C should be capital letter and P should be capital letter. Am I right? So,
yes, sir.
but the court will allow the amendment only if this amendment is necessary to determine. When the court will allow it, that amendment is necessary to determine the controversy between the parties. The purpose of this provision is to promote end of justice and not to defeat the law. They want to see the justice should be given to the parties, but not to the defeat the law. And hence, an amendment of the pleading can be made at any stage of the proceedings. Modify, change, amend. So these are the things. Proviso of the Order 6, Rule 17 states that court will not allow application of amendment after the trial has been commenced. Just before read, the proviso of the Order 6, Rule 7 says, the court will not allow the application of amendment after the trial has been commenced, unless court comes to the conclusion that party did not raise the relevant facts before the commencement of the trial. So, provided the conclusion they made it, the party did not raise the relevant facts before the commencement of the trial, this proviso gives the discretionary power to the court. What discretionary power? Either to allow the pleading to be amended or modified or altered, or not to allow. Because commencement of the trial is already made according to the proviso of the Order 6, Rule 17. So this proviso gives the discretionary power to the court to decide on the application of pleading after the commencement of the trial. So whether to entertain it after the commencement of the trial, what pleading amendment, or not to entertain. An institution of the suit is necessary for applying for the amendment of pleading. So one has to institute a suit. It is a must mandatory for applying the amendment of the pleadings. This provision was deleted by the Civil Procedure Amendment Code 1999. So the provision which is given is deleted. The omission was made to ensure consistency in the new changes in the Civil Code, but later it was restored by the Civil Procedure Amendment Code 2000. In the beginning, 1999, that provision is deleted again, but it restored the Civil Procedure Amendment Code in the 2000. This amendment has given power to the court to allow the application of the pleading with some limitation. So the proviso is eliminated because the proviso clearly says court shall not or may not, but generally the court will not allow after the proceedings has commenced. The trial has been commenced, but that provision is deleted in the 1999, again restored in the 2000 amendment of the Civil Procedure Code. So now, whether the provision is there or not, it is there with some limitations. With some participants, are you hearing me?
Yes, sir.
With some limitations it was there. Which one? Amendment to modify or change it after the commencement.
Allow application of the pleading with some limitations, sir.
Yes. So in the case of the Gurdayal Singh versus Rajkumar Aneja, the court stated that any person who is applying for the amendment of pleadings should state that what is to be altered or what is to be amended, what is to be modified in the original pleadings. So it would be clearly mentioned what should be altered, amended, or modified in the original pleading. That is decided in the Gurudayal Singh versus Rajkumar Aneja. S.R. Venunath, we are welcome. In the case of Rajesh Kumar Agrawal and others versus...
Good evening, sir. Good evening.
Yes, good evening. K.K. Modi and others, the court stated that amendment of pleading consists of the two parts. Number one, in the first part, the word may gives the discretionary power to the court to allow or disallow application of pleading once the pleading has commenced. Number two, second part. In the second part, the word shall gives obligatory direction to civil court to allow the application of pleading of this amendment is necessary for the purpose of determining the real questions in controversy between the parties. So now, different high courts have given a different opinion on this, whether amendments could be allowed after the commencement of the trial or not, or amendment can be done at any stage of the case. So, and here I noted down the two different opinion of the courts. Commencement of the civil trials and amendment of pleadings. In view of the Bombay High Court, because the two views are given, one is Bombay High Court, another is Calcutta High Court. Let me see what is the view of the Bombay High Court. In an important judgment delivered on reference made to a division bench of the Bombay High Court, Mahadio versus Balaji, that is the Mahadio case law, the High Court had to examine the two questions. Number one, whether a trial of a suit commences on the date of framing the issues or from the date of filing the affidavit in lieu of examination in chief. That is number one. That means from where we can see that trial has commenced. Either suit is commences on the date of the framing the issues or from the date of filing the affidavit in lieu of the examination in chief. And second point is whether the proviso to Order 6, Rule 17 is attracted after framing the issues or after filing the affidavit in lieu of the examination in chief. So these are the two aspects of it. The High Court referred to Vidya Bai case law, another is Ajendra Prasad ji case law, Kailash case law, and Madan Lal case law, as well as the expression proved, disproved, not proved in section of the Evidence Act 1872 as stated as under. So now, thus it can be seen that when the issues are framed, there is no engagement of judicial mind in the exercise of weighing the material before it in order to assess its worth. What is actually done to narrow down the area of the dispute and pinpoint the points required to be determined by the court. In other words, in the words of the learned judge, single judge, the issues are framed in order to navigate the direction in which the trial shall proceed so as to give clear idea to the parties regarding the burden of proof. Each one will have to bear and consequently about the right to begin with trial. So, where the trial is started, either it is started at the witness is examining or it is started when it is filed in the court, the charges. Yes, any comment?
Commencement of trial means when the actual trial takes place.
So it is from the date of the framing the charges.
No, not from the date of framing the issues. It is from the day when you do cross-examination.
Means in lieu of the cross-examination or
Yes.
cross-examination.
Yes, but however, what you have said somewhere may and shall.
Yes, may
You have
and
used
shall
the word
is
may
there.
and shall. shall is mandatory and may is obligatory. I think the statement what is written there is a little bit confusing.
Already they are given that the court has the discretionary to allow or not to allow. Because in 1999, the provision is Order 6, Rule 17 is deleted. Again, is instituted in the amendment of the civil procedure in the 2000.
But if you look into the recent judgment of Supreme Court, September 2nd, Supreme Court judgment, LIC versus some gentleman, some company, the Supreme Court has given very clearly any amendment of pleadings which comes before the court should be allowed. Court cannot reject it blindly.
At any stage of the case.
At any stage, I'll tell you about the case law.
Okay.
25 years back, when that person has filed a claim of 1 crore 10 lakhs,
okay,
he has made an application for amendment of plea of 400 crores.
My goodness, my goodness.
Yes. The Karnataka High Court single bench allowed it. The Karnataka High Court division bench allowed it.
Okay.
LIC has gone to Supreme Court. Supreme Court said nothing doing. The petition has to be allowed, and it has framed certain guidelines.
Okay.
When a petition should be allowed, when a petition should not be allowed.
Okay.
So any petition which comes to amendment of pleadings, it has to be allowed, but that discretion is there by the judge during the judgment time whether that amendment of pleading should be taken into consideration or not.
Okay, okay, okay.
But amendment of pleading application should be accepted.
So now this is one view of the Bombay High Court. But in the same way, if you happen to see the Calcutta High Court, Sri Ishwar Radha Behari Jew versus Malati P. Sani, reference made to the division bench of the High Court by a single bench on the following issue. Whether in view of the Vidyabai, Padmalata, means Maharashtra court decided it, commencement of a trial, as envisaged in the provision of the Order 6, Rule 17 of the Code of Civil Procedure, would mean that the date of first hearing, that is the date of framing the issues, or the final hearing of the suit, examination of the witnesses, or filing a document and addressing the arguments. The High Court conducted a threadbare analysis of Vidyabai, and the judgment referred to the Vidyabai, including the Madan Lal and Kailash and Baldev Singh, Mohinder Kumar and Anjana Prasad ji. Reference was made to the Bombay High Court judgment, Mahadev, as far as the observation in Kailash on the commencement of the trial. The High Court rightly observed that this observation in Kailash is not the ratio decidendi of the judgment, but the High Court further went into the state that observation in the Kailash are obiter and are of a great persuasive value. However, in others' view, has been mentioned earlier in Part B, the observation in the Kailash on commencement of the trial is stray observation and cannot even be considered as a obiter dicta. So, ratio decidendi and obiter dicta, you know it. Obiter dicta means because of that case, it may be allowed, but ratio decidendi, it can be used as a precedent. So overall, the High Court can went into the opinion that there is a distinction between when the trial stage commences in the life of a civil suit and when the trial actually commences. So the two things are there. Trial stage commences in the life of the civil suit and when the trial actually commences. Within the meaning of the provision Order 6, Rule 17, according to the Calcutta High Court, ordinarily, the trial stage commences in a suit immediately upon the issue being determined. However, it is not immediately thereupon that the trial in a suit commences in a right earnest, and the commencement of the trial is only when any witness takes the box, whether prove his affidavit of evidence or to prove any document be tendered into evidence or face any cross-examination for it. So it is at this stage the court applies its judicial mind to examine the evidence or to consider whether a particular document is to be received in evidence or to consider the permissibility of the question put in the cross-examination. It is also open to the court to put its own question to the witnesses, and then court does so. It surely applies the mind of the purpose of assessing the merit of this list. List means, is it a list pendants?
Yes, 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 yes.
Okay, list. So now they say, when a court will say the commencement of proceeding at that instance only when a witness comes into the witness box.
Yes.
So that is the opinion they have taken by the Calcutta High Court. But as you said, no, at any stage. So here they say,
Yes, yes.
in the author's opinion, in view of the Calcutta High Court is correct, that of a Bombay High Court is incorrect. In a civil proceedings, only the battle line are drawn with the framing of the issues and the filing of the affidavits. It is only when the witness steps into the witness box that is the real charge begins by the counsel. This is when the trial starts. Of course, it is a dispute about when the trial starts, by framing the issues or the witnesses come into the witness box. So they made the thing. However, in the absence of the clear and definitive pronouncement by the Supreme Court, and when a civil trial commences for the purpose of the Order 6 Rule 17, the meaning of expression commencement of trial would always be subject to different interpretation by the courts, depending upon the fact each case before it. Therefore, in the author's opinion, the remedy in this situation, the legislator must up its game and make the following amendments to Order 6 Rule 17. What they say? Adding an explanation of the provision to Order 6 Rule 17, defining the expression commencement of a trial, or amending the provision of Order 6 Rule 17 by replacing trial has commenced. So, and commencement of trial with issues are framed and framing of the issues. In other words, amendment of the pleading should not be permitted after the issue are framed. An explanation could added clarifying the framing the issues would also mean that include the framing of additional issues and recasting the issues under the rule. But as you made it very much clear that Supreme Court has made a stand that pleading can be amended at any stage of the case. Proceedings. So that is the present position.
The latest judgment is Life Insurance Corporation of India versus Sanjeev Builders Private Limited.
Okay, that is the latest judgment. Repeat.
Life India, LIC, Life Insurance Corporation of India versus Sanjeev Builders Private Limited.
Okay, Sanjeev Builders Private Limited. LIC versus Sanjeev Builders Private Limited. There the Supreme Court made it very much clear. At any stage, a pleading can be amended.
Yes.
So that is the present position. We can say it.
It's written in the judgment. It is written. The learned counsel pointed out that at the time of the suit, came into institution, the damages were to the tune of 1 crore 1 lakh.
Yes.
In alternative, was prayed for by the way of amendment. The damages now prayed is for tune of 400 crores 1 lakh.
That means amendment will be allowed.
Yes.
So now let us see. Why do courts allow the amendment of pleadings? If
what happens
is it not the injustice to the party?
No. It is what happens during the course of the case. Some new evidence may come out, some new adjectives may come out. So you cannot जिस टाइम पे आपने केस फाइल किया उस टाइम पे हालत अलग था. अभी as a case going on, you might come up with some new records, new evidence. तो वो आपको प्रोड्यूस करना पड़ेगा.
Okay. So now why do court allow the amendment of pleading? For answering this one, the primary objective for the court to allow application for the amendment of pleading is to secure the ends of the justice.
Yes.
And prevent injustice to the other parties. That is the actual aim, to allow the pleadings to be entertained. Also, this amendment is necessary for the purpose of determining the real question in controversy between the parties. So amendments of pleading help the parties to correct its mistakes in the pleadings. In the case of the Cropper versus Smith, the court stated that object behind the amendment of pleading is to protect the rights of the parties, not to punish them for the mistake made by them in the pleadings. Very clear it is made. Is it not?
Yeah.
And what can be amended in pleading? Plaint filed by the plaintiff, written statement filed by the defendant, importance of the doctrine of relation back in amendment of pleadings. When the court allows the application of the amendment of pleadings, then it relates back to the date of suit. But in the case of the Sampath Kumar versus Ayakannu, the court stated that in some special cases, the court can direct the amendment of pleading will not relate back to the date of suit. Again, it depends upon the merits of the case, whether it should be retrospective or it should be a prospective. Am I right?
Prospective amendment तो होने के बाद ही होगा ना सर, retrospective रहेगा amendment.
नहीं, लाने के बाद नहीं, और जब से implement होता हो. But when you want to get the justice, it should be the retrospective. As you said, no, 1 crore damages now leads to the 400 crores. What is that? LIC case law, Sanjit Builder case law, Supreme Court.
I'll forward the judgment copy to you.
Okay, please post it so that I can post to them. Even or you can directly post in the group also, both the groups.
Okay.
So now, amendment of pleading when granted. In the case of Krishna Das Vithoba Bachelor, the court stated that there are 2 necessary conditions to be satisfied before granting leave for amendment of pleadings. Number 1, this grant of leave should not lead to the injustice to the party. Number 1. Number 2, this amendment pleading is necessary for determining the real question of controversy between the parties. These 2 conditions should be there. Then only the court will grant the plea of amendment.
Okay, I will read out what Supreme Court said in this Sanjeev Builder's case.
Yes, please read.
All amendments, what the Supreme Court said.
Yeah.
All the amendments are to be allowed which are necessary for determining the real question in controversy, provided it does not cause injustice or prejudice to other party.
Definitely.
It's mandatory as is apparent from the use of the word shall.
Yes.
In the later part of the Order 6, Rule 17 of CPC.
Very good.
The prayers for the amendment is to be allowed.
Yes.
If the amendment is required for effective and proper adjudication of the controversy between the parties.
Yes.
And to avoid multiplicity of proceedings.
Good.
The amendment does not result in injustice to other side.
Naturally.
By the amendment, the party seeking amendment does not seek to withdraw any clear admission made by the party which confirms a right on the other side.
Okay.
The amendment does not raise a time-barred claim.
Okay.
Resulting in diversity on the other side of a valuable accrued right in certain situation.
Yes.
A prayer for amendment is generally required to be allowed unless by the amendment a time-barred claim is sought to be introduced.
Okay.
In which case the fact of the claim would be time-barred becomes a relevant factor for consideration.
Okay.
The amendment changes in the nature of the suit.
Okay.
The prayer for amendment is malified.
I see.
Or by the amendment, the other side loses a valid defense.
Okay.
In dealing with a prayer for amendment of pleadings, the court shall avoid a hyper-technical approach.
Okay.
And is ordinarily required to be liberal, especially when the opposite party can be compensated by cost.
Yes.
Where the amendment would enable the court to pinpointedly consider the dispute and would aid in tendering a more satisfactory decision,
Okay.
the prayer for the amendment should be allowed.
Naturally. Okay. Of course,
Where
the
the
guidelines
amendment,
are there when it could be allowed, when it could not be allowed, and why the object of it to avoid the controversy between the parties or to come to an justice to the party. Otherwise, they will irreparable loss to the party if the pleading is not allowed over there. So these are all the circumstances they will consider it.
or a last point, delay in applying for amendment alone is not a ground to disallow the prayer.
Very good.
I mean, the delay ho gaya, to you cannot say we cannot, the court cannot say we are not allowing petition, an amendment petition.
Okay.
Where the aspect of delay is arguable,
Okay.
the prayer for amendment could not be allowed, and the issue of limitation framed separately for decision.
Okay. Okay.
They have given some 10 points, 10, 12 points they have given.
Those guidelines should be followed when you want to amend the pleading.
Yes, this is done on September 1st, 2022.
Very good. So I need not to go through these all cases now because you have given the grand norm first. So,
Latest one,
yeah. So these are all not to be seen now. We need not to worry about this one. What are the step 1? What are the step 2, step 3, and court application needs to the flip pleadings and so because it is already covered over there. So now let us go to the another point. Let me see whether the court stated is disputed for the application of the amendment. Again, the amendment is words. Of course, we made what is Order 6, Rule 17 criticized. Now there is no question of criticize because the Supreme Court is made very much clear.
Yes.
Is it not? Yeah, now let us see that what happens when an applicant fails to amend in prescribed time. I think.
Yes, that is Rule 18.
Okay.
What happened is that
Yeah.
whenever the court allows the amendment of petition application within 14 days, as per Order 6, Rule 18,
Okay.
within 14 days, whoever is making an amendment application should submit to other party with the latest amendment. If it doesn't give within 14 days,
Okay.
then the court will not allow him to do again in the next time.
Okay. No. So that is the limitation.
He loses his chance. He cannot come. He cannot come and say, I was this thing. No, you have given 14 days time. So you have lost the chance, the amendment pleadings.
That's over.
That's over. 14 days immediately after that.
Okay, now let us see the plaint and written statement. What is the plaint and what is written statement? Could you explain?
You want me to answer or you want
No,
that?
you explain. What is plaint and what is written statement?
Plaint is a thing where I file a suit against someone in the form of my facts briefs.
Okay.
It's a petition of the petitioner, of the applicant, petitioner,
Or we can say plaintiff also.
plaintiff also.
Okay.
And written statement is where a person who gives his reply, that is the defendant, respondent, disputant, opponent, so not disputant, opponent.
Opposite
So
party.
that is called opposite party. He gives his reply, that is called written statement. And that has to be done within 30 days.
Okay. And the plaint, the cause of action consists of 2 divisions. First is the legal theory, the actual situation based on which the plaintiff claims to have suffered. And second is the legal remedy that the plaintiff seeks from the court.
Yes. Next thing is that you should also mention the limitation, whether that suit is barred by the limitation or not barred by the limitation.
And can we also say the jurisdiction?
Yes. Limitation aega, jurisdiction aega, and you have to also mention what is the prejudice going to cost to you, what is the loss is going to cost to you if your petition is not allowed.
Okay. That means the remedy should be there.
Yes. And by not allowing this application or by not admitting my petition, what is the loss I'm going to happen? What is the loss I'm going to face?
And it should be clearly mentioned.
Yes.
So a plaintiff.
And last thing is that what are your prayers?
Yes, that is true. What is that thing?
That is true.
Because
And
I was injured.
Yes.
My rights are violated. and
Yes.
hence I should be compensated.
Compensated. Anything, if you want any interim relief,
Okay.
because normally क्या होता है, पिटिशन फाइल करने के बाद आपका टाइम लगता है बेंच पे आने के लिए, सब होने के लिए.
So we can ask for the interim relief also.
Yes, you can ask for interim relief. उसके साथ साथ along with the application, along with the petition, you also have to file for an interim relief for urgent hearing.
Okay.
Yes,
So a
ये
plaint
procedure.
is considered an important concept because it is the foremost and the initial stage to initiate any lawsuit and helps to find a civil court of appropriate jurisdiction. So Order 7 of the Code of Civil Procedure deals particularly with a plaint. Then in Order 7 CPC, there are many different rules which deal with the different constituent of the plaint. Rule 1 to 8 deal with the particulars of the plaint. Rule 9 of the CPC deal with the how the plaint will be admitted, and after the Rule 10 to 10 capital B talks about the written of the plaint and the appearance of the parties, and then main rules 11 to 13 deals with the rejection of the plaint, in which the circumstances the plaint can be rejected. So from Rule 10 to 13 clearly mentioned about the plaint, how it would be, when it would be admitted, what are the grounds to be there, when it will be not allowed, when it will be returned back, rejected. Is it right?
Yes.
So section 26 of the Code of Civil Procedure states, every suit shall be instituted by the presentation of a plaint or in such other manner as may be prescribed. This section clearly shows that plaint is very much necessary for the establishment of a suit before a civil or a commercial court. Necessary contents of a plaint. A plaint is a legal document that contains a lot of necessary content, in the absence of which it cannot be considered as a plaint. The contents necessary for the plaint are mentioned in the Rule 1 to 8 of the Order 7 of the CPC. These are all mentioned below. Number 1, plaint should contain the name of the commercial or civil court where a suit will be instituted or initiated. Plaint should contain details of the plaintiffs such as the name, address and description. Venunath, some people write there alias. What is alias?
Alias is known by other name.
Such a nickname. Okay, that is a nickname. Alias they will write it.
Actually वो नहीं लिखना चाहिए. Alias बोल के लिखते हैं. But ठीक है, some courts they accept. Normally courts should not accept those kind of terminologies.
Okay. That's why I saw some of the plaint. Yeah, when the addresses are there, I saw it. The plaintiff, defendant, they say alias and so forth.
You should not write. You should write them known as. You should write.
Acha. It's known as.
People write. Okay.
He also be known as.
Yes.
So that is the second point. And third, plaint should contain the name, residence, and description of the defendant also. Could you mention the age also?
Yeah.
And the profession?
Yeah, age is necessary.
Okay.
If the court has to declare some judgment or anything, especially in criminal cases, if a person is of 80 years, अगर कोई 80 साल का बुढ़ा आदमी है,
yes,
बुजुर्ग आदमी है, अगर उसको सजा देने तो already is 80 years, he is in the deathbed, उसको क्या सजा देगा अभी court?
Okay.
That's why they mentioned to know whether if any monetary compensation can be taken from him. So each age also will be taken into consideration. If this person is put behind the bars, how many years he can work, कितने में अपन उसको पैसे निकाल सकते हैं, वो सब इसके लिए important है.
अच्छा. Okay. So age should be mentioned there.
Yes, age, gender.
Okay, even that. Okay, you are right. Gender also be there. Married and unmarried.
Actually जरूरत नहीं है, but people write. I'm an Hindu, I'm a Muslim, I'm a Christian. Actually वो सब जरूरत नहीं है. Was this concept was there right from the British ज़माने के time पे, though we still follow those terminologies only.
Okay, okay, okay.
Hindu, Indian, Indian TK, Hindu, Muslim, Christian लिखने की जरूरत नहीं, क्या करना केस है उससे.
Okay, okay. Unless until it is a family issue.
Family issue, or when it comes to
Personal law.
matrimonial dispute,
Personal law.
personal law. If a Hindu is marrying a Christian, or a Christian is marrying a Muslim, or a Muslim marrying a Christian, Muslim, Hindu, then you need to write those things.
Okay, okay. Otherwise, it is not necessary.
It's not necessary.
Right. So now, when a plaintiff has some defects or problem in health or any type of disability, the plaint should contain the statement of these effects. That means he should have to write if it is a physically challenged or mentally challenged
yes.
or mentally retarded. The physical status of a person also be written over there. The plaint should contain the facts due to which cause of action arises, and where the cause of action arises, it should also be mentioned. So we have to make it very much clear to the judge the cause of action arises, and hence the cause of action arises, and this is the remedy that we want, and the court is having the jurisdiction to entertain because cause of action in the particular jurisdiction. Is it?
That's why we write that jurisdiction clause.
Okay, okay, okay. So plaintiff should not only mention the facts due to the which cause of action arises, but also those facts which help in recognizing the jurisdiction. Okay, now it is made very much clear. And the plaintiff should also contain about the relief which the plaintiff seeks from the court. So is it not the prayer? Is it the prayer only? Is it?
Yes, it's a prayer only. It's a prayer only.
Okay, plaintiff should contain the statement of the value of the subject matter suit not only for the purpose of jurisdiction but also for the purpose of the court fee. Yeah, that is true.
Yes, you have to pay court fee. You have to write now.
Yeah, because they cannot show it the value of the subject matter is less, because if the less matter would be there less court fee, if the more matter would be there more court fee. I mean the cost of the value of the subject matter. So at last, the content that should be in plaint is the plaintiff verification on oath. So verification of the oath also is important. And that's why the people will sign no. He attestation by the plaintiff, attestation by the advocate that he signed in presence of him. Is it not?
No, that is different, and affidavit is different.
Affidavit is different. Of course, affidavit is different. But when a person has given a statement, it should be endorsed by an advocate again.
Yes.
So this shows that plaint is necessary component for the successful initiation of the suits in commercial or civil courts and plays a very important role throughout the suit. Some additional particulars which were not mentioned above include the following. Plaintiff shall state the exact amount of the money to be obtained from the defendant as given under the Rule 2, Order 7, whereas the Rule 3 of the Order 7 of the CPC states that when the plaint contains the subject matter of the immobile property, then the property must be duly described. Of course, it is very clearly given amount and the property and the exact thing. It should be clearly mentioned as it is given in the different rules and orders of the CPC. So now, at any time it will be closed, still the time is there. And the rejection of a plaint. The plaint shall be rejected in certain situations when requirements are not fulfilled. Some of the situations whose the plaint is rejected are as follows. So the plaint is rejected in a case where the cause of action is not disclosed. Okay. If the cause of action is not disclosed, then it is not possible to prove the damage caused to the plaintiff. Nice. To seek relief against the defendant, the facts needs to be mentioned clearly. In the case of S&P Shipping Service Private Limited versus World Tanker Carrier Corporation, the plaint was rejected. The suit is dismissed under Order 7 Rule 1A of the CPC 1908 because it is not clearly mentioned. Am I right?
Yes, even there is another provision also.
Okay.
If a person is not able to pay court fees.
Okay, even that, deficiency of the court fee, they can remind, they can ask do the reject or they will remind.
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
जय हिंद।